There has been a surge in private data usage across several industries in recent years. Today, private data is essential in processing transactions, making purchases, conducting surveys, and carrying out a host of other activities. But while that is the case, many have fallen victim to the non-consensual trade of their personal details, as some sites have been found guilty of selling customer data to the highest bidder. It goes without saying, deliberate efforts should be made to continue protecting our data through adequate regulation of its collection, processing, and storage. Did you know Uganda was the first East African country to recognize privacy as a fundamental human right, as observed in Article 27 of the 1995 Uganda Constitution, which states, "No person shall be subjected to interference with the privacy of that person's home, correspondences, communication, or other property." Fast forward, the Data Protection and Privacy Act was enacted in 2019 as a development of the Constitution with the aim of protecting individuals and their data by regulating the processing of personal information by state and non-state actors within and outside Uganda. As a data center purpose-built to Tier 3 standards, delivering best-in-class co-location, cross-connect, fiber and IT infrastructure services, we are committed to supporting sector players with data protection regulations, which is critical to compliance with the Data Protection and Privacy Act. Listen as Celine Nantumbwe, an associate at KTA Advocates, speaks on the Data Protection and Privacy Act and what it means for Uganda as a country.
Hi, my name is Celine Nantumbwe. I'm a junior associate and executive assistant at KTA Advocates. It's an IP specialized firm, and I particularly work under the practice group, which is TMT and IP. That's technology, media, telecommunication, and intellectual property. I'll start by defining data protection and privacy. It's a set of rules and regulations that define how personal data, that is data that can identify an individual such as their name, their address, their date of birth, how such data is collected, used, stored, and also shared if need be. Why it's important to individuals is that the Data Protection and Privacy Act gives you rights in regards to that data. Rights that you can exercise in order to enable you to keep having power over your data, so to speak. An example is the right to consent. Before they collect your data, in most situations, you must consent to them collecting your data. Another is the right to be forgotten. If you don't want data about you kept by an institution, you have the right to ask them to delete it. Why it's important for organizations is because organizations are mandated, or entities that collect, process, or control data are supposed to follow the obligations under the Data Protection and Privacy Act. So a lack of data protection and privacy affects individuals because if you do not have power over your data, then even when your data is misused, you do not have right to redress over it. So that's one of the things that the Data Protection and Privacy Act ensures, that number one, you have control over your data, how it's used, you know exactly who it's going to be shared with ideally, and you have the right to consent over that. And if it's used in a way that you do not agree to or it's not founded in law, you have a right to redress. Why it's important for organizations, of course, to comply with the law, but on top of complying with the law, in order to ensure that your reputation is intact as people who respect data protection and privacy and the privacy of the data subjects whose data you hold. What are the risks and consequences of a data breach? Of course, the first risk and consequence of a data breach is the reputational risk that you run when data subjects find out that there was a breach in your institution. The second is if the reason why maybe that breach happened is because you're not ideally following your obligations under the law as a data controller, data collector, and data processor, you run the risk of also getting a sanction. Yeah. One of the ways in which the law tries to breach this, in order to ensure that data breaches are attended to in a manner that suffices, is it requires that when there is a data breach, that is when an unauthorized person gains access to personal data that you hold as an entity, that you report it to the authority. And on top of reporting it, you're supposed to tell them exactly why that breach happened, which mechanisms you took in order to remedy that breach, and they can then inform you on whether, number one, you're going to inform the data subjects whose data was breached, and how exactly they also give you guidance, I would say, on how to remedy that breach in order to ensure that it doesn't happen again. Maybe for future reference, then if you are to act as a data breach, you must ensure that you buff up your cybersecurity in order to avoid further breaches in future. How can organizations comply with the Data Protection and Privacy Act? Number one, if an entity is just it's just starting out, I would say, first they need to understand the data that they collect, what the data is used for, if they share it with anyone, and then around that, then they can build processes, because I think every organization has processes, from maybe how a customer is onboarded to how the data is deleted. They then design their processes to ensure that all the obligations of the Data Protection Act are taken care of through those processes. So this may be coming up with policies, that is maybe a privacy policy, in which you state which data that you collect and how it's used, who you share it with. This privacy policy should be shared with the employees to ensure that that is actually how they're using the data, and with your customers. That's to ensure that there's transparency and accountability. It can also be from things like information security policies, which basically shows how a company's information security or information systems are used. So let's say we all have policies as to, at the end of the day, you clear your desk or you put your documents away. That's one of the things under an information security policy. So on top of that, another way is obviously training your staff to ensure, because at the end of the day, it's the staff or your employees that interface with this data. So ensuring that they know their obligations and that they are following those processes where data protection and privacy is embedded. So continuous training of employees is also extremely important. Third is knowing that when you're sharing, when you have data, let's say as an entity, sometimes you obviously need to share it sometimes in order to, let's say, ensure that contracts are fulfilled, or just generally you share it for purposes of whatever it may be. However, the point being that those people that you share the data with, or those entities that you share the data with, also have the same obligations in regards to that data in terms of protecting it and ensuring that that data that they are acting in line with the Data Protection and Privacy Act. Normally, you sign what we call a data sharing agreement, where you put that all in contract of assuring that the person actually has those mechanisms in place. However, that's to say that even third parties who receive data are also obligated to ensure that they are complying with the Data Protection Act.
Thank you, Celine, for your valuable insights, and to everyone who strongly supports the protection and privacy of all data. As we observe Data Protection and Privacy Day, it is important to remember that our data is a valuable and sensitive asset that should be protected to the fullest extent.